Okay, let's unpack this. Today, we're embarking on a deep dive into something truly monumental for India, the very bedrock of its new criminal justice system.
Mm,
We're talking about the Bhartiya Nyaya Sanhita 2023, or BNS 2023.
right.
And this isn't just a tweak to old laws, it's a comprehensive reimagining, a legislative earthquake, really, that will reshape how justice is defined and delivered across the entire country.
It absolutely will. The scale is immense.
So our mission for this deep dive is to lay bare the first principles of the BNS. We want to understand its core philosophy, how it actually intends to operate, and how it defines the absolutely crucial legal concepts that underpin everything else.
The very foundation.
Exactly. Think of this as your essential roadmap, your shortcut to being truly well-informed about this pivotal legal transformation. We're not just reading the text here, we're really seeking those aha moments, the things that reveal the true implications, the subtle shifts, maybe even the surprising facts embedded within these foundational sections.
And what's truly fascinating here, beyond just the sheer scale of the legislation, is the immense academic and practical responsibility it represents.
Right.
A statute like the BNS isn't just a collection of rules. Well, it's like a meticulously constructed edifice. These initial provisions, in particular sections 1 through 13, they're the foundational bricks, the actual blueprint. Understanding their nature, their object, scope, application, and crucially, their interpretation, it isn't merely an academic exercise. It's like learning the very grammar and vocabulary of a new legal language.
That's a great analogy, learning the language of the law itself.
Precisely. Without this foundational comprehension, trying to navigate the subsequent more complex provisions, it would be incredibly challenging. We're essentially setting the stage here, not just for legal professionals, mind you, but for every curious mind wanting to grasp the mechanics and, importantly, the intent behind this new era of justice in India.
Okay, learning the language. I like that. And to truly understand the spirit of any language or, well, any law, we often have to look beyond just the operative words, right? We need to delve into its preamble.
Exactly. The preamble is key.
Yeah, this is a part often overlooked, I think, but as you say, absolute crucial. So here's where it gets really interesting. The preamble of the BNS 2023, which is reflected in its long title, states, "An act to consolidate and amend the provisions relating to offenses and for matters connected therewith or incidental thereto." Now, on the surface, that sounds quite straightforward, maybe even a bit, dry.
It can seem that way.
But what does this seemingly simple sentence actually tell us about the ambition, the legislative intent behind this new comprehensive law? What's sort of hidden power in those words?
Well, that seemingly simple sentence, as you rightly perceive, it is the veritable key. It unlocks the profound legislative intent behind the BNS 2023. Its core concept is nothing less than a comprehensive overhaul and unification of substantive criminal law in India concerning offenses.
An overhaul and unification. Okay.
Yes, and the primary objects are clear and twofold, each carrying significant implications and, each word chosen with immense care.
Right.
Firstly, to consolidate. Now, this isn't just about gathering existing laws like, say, collecting disparate books on a shelf.
It's more active than that.
Much more. It implies the systematic integration, the combining of fragmented legal provisions, primarily from the Indian Penal Code of 1860, which, by the way, has seen countless amendments and judicial interpretations over 160 years.
A long history.
Into a single cohesive statute. The goal here is deeply profound, to bring order, clarity, and accessibility to a legal framework that had over time become this incredibly complex tapestry of old and new.
So simplification in a way, or at least making it more coherent.
Coherent is a good word.
Right.
The aha moment here is recognizing the sheer administrative and legislative challenge this presents. I mean, how do you consolidate almost 2 centuries of legal evolution without inadvertently altering established judicial precedents or creating new ambiguities?
Yeah, that sounds like a tightrope walk.
It absolutely is. It's aimed at achieving a unified, easily understandable, and more efficient body of law. But the process itself is far from just a copy-paste job. It requires immense legal skill.
Okay, so that's consolidate. What about the second part?
Secondly, to amend. This signals a forward-looking legislative intent, a clear recognition that law must evolve. It has to.
It can't be static.
Precisely.
Yeah.
It means modifying, altering, adding to, or even repealing existing provisions. The purpose here is manifold. Address contemporary societal needs. integrate the jurisprudential developments that have emerged over decades. Think about how our understanding of criminal intent or even types of evidence has changed.
Right, technology alone changes so much.
Exactly. And, crucially, to tackle new and emerging challenges in the realm of criminal law that the old code, drafted in 1860, simply couldn't have anticipated. This aspect truly speaks to modernization. It's an explicit acknowledgement that the world, and crime with it, doesn't stand still.
So consolidation looks back to bring order, amendment looks forward to stay relevant.
You got it. And then we have that expansive phrase, matters connected therewith or incidental thereto.
Ah, yes, the catch-all bit.
Well, it might seem like that, but it's where the preamble truly flexes its muscle, in my view. It might appear innocuous, but it signals a comprehensive ambition far beyond just defining and punishing specific offenses. It means the BNS seeks to cover ancillary aspects, things intrinsically linked to offenses, ensuring a holistic legal framework.
Holistic. Okay.
It grants the Sanhita immense flexibility, allowing it to include provisions that support its effective application and interpretation. This allows it to adapt, potentially, to unforeseen future scenarios or address gaps that might emerge. So the basic ingredients are clear: consolidation for order, amendment for modernization, and this inclusion of connected matters for comprehensive reach and, well, future-proofing.
That makes sense. It's laying out its entire philosophy right there.
Exactly. So when we dissect the nature of the BNS 2023, as indicated by this preamble, it's primarily a consolidating and amending statute in substantive criminal law. It aspires to be the principal code defining offenses and prescribing punishments in India.
The main source book for criminal law.
Precisely. Its scope, consequently, is vast. It aims to cover the entire spectrum of criminal offenses. And that connected or incidental matters phrase, as I mentioned, grants it a particularly expansive reach, allowing for provisions that ensure effective application across the board.
Okay. And based on that, what would you say are the sort of standout features?
From these core ideas, we can discern several salient features. First, it aims to be a comprehensive code, an exhaustive body of law for offenses. Second, the amend aspect clearly points to modernization addressing new forms of crimes, like cybercrimes, maybe aligning with evolving societal values, perhaps even international standards in some areas. And third, consolidation inherently leads to systematization, presenting criminal law in a more organized and hopefully more accessible manner.
Comprehensive, modern, systematic.
Got it. So it's not just an update, it's a complete structural overhaul, really, with an eye towards what's coming next. But when you talk about interpretation, especially for something so foundational, how do courts actually use this preamble? Is it just a kind of poetic introduction, or does it have real teeth in a courtroom?
Yeah, that's a crucial question, and the answer is unequivocally, it has real teeth. The preamble is a vital tool for statutory interpretation.
Okay.
In situations of ambiguity within the operative provisions, and believe me, in law, ambiguity is often unavoidable, it crops up.
I can imagine.
The preamble serves as a guiding light. It helps understand the legislative intent and the mischief, as the legal term goes, that the statute seeks to remedy.
The mischief, what does that mean exactly?
It refers to the problem, the defect, or the issue in the existing law or society that the new legislation aims to fix or address. This aligns directly with the well-established mischief rule of statutory interpretation, sometimes called Hayden's rule.
Ah, okay. So it helps figure out what problem the law was trying to solve. Precisely. For example, imagine a scenario where a new, sophisticated form of, say, digital harassment emerges, something not explicitly named in an older traditional section of law. If its criminality under a specific BNS section is debated, the preamble's stated objective to consolidate and amend the provisions relating to offenses would strongly support an interpretation that does address such modern mischief, provided, of course, the language of the provision itself can reasonably bear that interpretation.
So it guides the interpretation towards the law's purpose.
Exactly. It guides judges to look beyond just the literal word to the underlying problem the law was designed to solve.
Has the Supreme Court weighed in on this, the importance of the preamble?
Oh, absolutely. The Supreme Court of India has consistently held that the preamble is an integral part of a statute. While it's not typically a source of power in itself, it's invaluable for interpretation. Even in constitutional law, think about landmark cases like Kesavananda Bharati. The Supreme Court emphasized the preamble's significance in understanding the basic structure and objectives of the Constitution itself.
Right, a huge case.
And this principle is directly extendable to ordinary statutes like the BNS. The preamble illuminates the core legislative purpose.
So it's not just fluff at the beginning.
Definitely not.
Yeah.
It also connects to the legal maxim of verbis legis non est recidendum, From the words of the law, there must be no departure. Now, while this emphasizes sticking to the literal text, the preamble provides essential context and spirit when the words themselves aren't entirely plain. It guides us to the true intent behind them.
Okay.
There's a quote from Sir John Nichol back in 1826 in Brett v. Brett, where he said something like, "It is to the preamble more especially that we are to look for the reason or spirit of every statute."
So centuries-old wisdom still applies.
Indeed. This preamble, therefore, doesn't just introduce the BNS. It sets the intellectual and philosophical stage for a renewed framework of criminal justice. It's our first real aha moment. The preamble is not just decoration, it's an active interpretive tool.
Okay, so the preamble is truly the compass, defining the why behind the law. But the next logical question, if we're learning this new legal language, is how does the law actually define its own reach? Where and when does it apply? And importantly, to whom?
That's the perfect segue. Knowing the why is crucial, but then we immediately need the practicalities.
Defining the domain, Section 1, identity, commencement, and application.
Exactly. The practicalities. Where does this new law apply and to whom? So what does this all mean for, the average person and also for the legal system itself? Let's shift our focus to Section 1 of the BNS. It deals with short title, commencement, and application. This, to me, sounds like the foundational framework for the Act's identity, its operationalization, and its precise reach, the very boundaries of its authority.
Indeed, Section 1 is quintessential for any statute. It acts as its birth certificate and its geographical map, if you will.
Birth certificate and map, I like that.
It establishes the formal identity, the mechanism for its operationalization when it actually starts working, and the precise scope of its applicability, both territorially, meaning where, and in terms of the persons it covers, meaning who. The core concept is to define precisely when, where, and to whom the Bhartiya Nyaya Sanhita will apply. Its object is simple but vital. Ensure absolute clarity and legal certainty regarding the Sanhita's reach right from its very inception. Avoid any ambiguity about its authority.
Okay, clarity and certainty. Let's break it down.
Let's delve into its detailed subsections. Subsection 1 is straightforward. This act may be called the Bhartiya Nyaya Sanhita 2023. This is the formal citation, its official name.
Right, the title.
And the choice of Bhartiya Nyaya Sanhita itself reflects a deliberate intent, I think, to indigenize the nomenclature of the country's primary penal law. It marks a cultural and linguistic shift from its predecessor, the Indian Penal Code. It's a subtle, but I believe significant statement about identity.
A move away from the colonial legacy in name, at least.
Potentially, yes. Then, subsection 2 addresses commencement, how it starts. It stipulates that the Sanhita will come into force on a date, or even different dates for different provisions.
Oh, so it can be staggered.
Yes, exactly. Appointed by the central government via a notification in the official gazette. This phased implementation is often essential for such large-scale legislative changes. It provides crucial time for administrative preparedness, think police training, judicial infrastructure updates, and also for public awareness campaigns.
Makes sense. You can't just flip a switch on something this big.
Precisely. It's a standard legislative practice to allow for a smooth transition. And as per the official notification that came out, most of the BNS is set to come into force on 1st July 2024.
Okay, July 1st, 2024. Is everything starting then?
Almost everything. There's a specific exception mentioned, subsection 2 of Section 106. This relates to causing death by rash and negligent driving, specifically by a registered medical practitioner during a medical procedure. That particular provision has a different commencement mechanism, or at least its operationalization is handled differently, underscoring the granular control the government can exercise over the rollout.
Interesting. So not quite a big bang, but a strategic, staggered launch. That makes sense for such a massive overhaul. What about where it applies?
Exactly. Then we come to subsection 3, which defines the intraterritorial application. Inside India. It states, every person shall be liable to punishment under the Sanhita and not otherwise for every act or omission contrary to the provisions thereof, of which he shall be guilty within India.
Okay, every person within India sounds comprehensive.
It highlights two critical principles here. Firstly, the principle of legality, often expressed in Latin as nullum crimen sine lege, nulla poena sine lege, no crime without law, no punishment without law.
Right, you can only be punished if the law specifically forbids it.
Precisely. It emphasizes that a person can only be punished for an act or omission if it is specifically made an offense under this Sanhita. The phrase, "and not otherwise," reinforces that the BNS is the governing code for the offenses it covers within India's territory.
Got it. And the second principle?
Secondly, territorial jurisdiction. The Sanhita applies to offenses committed on the land, the water, and the airspace of India. Every person here is interpreted very broadly. It includes citizens, non-citizens, and even juridical persons like companies, if the nature of the offense allows for corporate liability. This is the classic foundational rule for criminal jurisdiction.
Standard stuff applies within the borders. But what about outside India? Does it reach beyond?
It does. Moving beyond India's physical borders, subsection 4 provides for extraterritorial application for persons liable under existing Indian law. It acts as a crucial legal bridge.
A bridge? How so?
It essentially says, if any other Indian law makes a person amenable to Indian courts for an offense committed abroad, then the BNS will apply as the substantive law defining the offense and punishment, just as if the act had been committed within India. It ensures a consistent substantive legal framework, no matter where the crime was committed, provided there's an existing legal pathway, usually procedural, to bring that person before an Indian court.
Okay, so if another law says India can try you for something done abroad, the BNS tells you what the crime is and what the punishment is.
You got it. Then, subsection 5 expands on specific heads of extraterritorial application, reaching even further, reflecting modern realities. Clause A covers offenses committed by Indian citizens anywhere outside India.
So an Indian citizen is bound by BNS wherever they are in the world?
Essentially, yes. This is based on the well-established nationality principle of criminal jurisdiction. The Sanhita itself provides a clear illustration. If an Indian citizen commits murder abroad, say in London, they can be tried and convicted of murder in any place in India where they might be found later.
Wow, okay. That's a long reach. What else?
Clause B applies to any person, regardless of nationality, on Indian-registered ships or aircraft, wherever they may be.
The floating island idea.
Exactly. It's rooted in the flowing island theory, or the law of the flag, treating these vessels as extensions of Indian territory for legal purposes. So if a French national assaulted another French national on a Mumbai-registered cargo ship, even if that ship was docked in, say, South Africa at the time, that act would still be subject to BNS 2023.
That makes perfect sense for sovereign vessels or registered ones. But Clause C is the one that really jumps out at me, especially with how crime is evolving today. It applies to any person anywhere committing an offense targeting a computer resource located in India. That feels like a huge leap, doesn't it?
Oh.
What are the practical implications of a provision like that?
This is truly a significant inclusion, yes, a crucial aha moment that reflects the challenges of modern crime, particularly cybercrime. Clause C is a direct response to that reality. It establishes jurisdiction based on the effect or targeting principle.
Effect or targeting. So it doesn't matter where the criminal is, only where the target is.
That's the core idea, regardless of the offender's nationality or physical location. This is a clear nod to the evolving nature of crime in the digital age, where geographical borders are often, frankly, irrelevant to perpetrators.
So give me an example. How would that work?
Okay, imagine a person operating from, let's call it country X, a nation far from India. They launch a sophisticated phishing attack specifically targeting customers of a bank whose main servers are physically located in India. Under this provision, Section 15C, that person, even if they never set foot in India, could theoretically be tried under the BNS.
Theoretically, what are the hurdles?
Well, the real-world implication and the insight here is that while this clause is crucial for expanding India's legal reach against digital threats, it also sets the stage for potentially unprecedented international legal battles.
Like extradition.
Exactly. How do you compel a nation like Country X to extradite a cybercriminal who has never visited India? How do you effectively investigate or seize digital assets across borders? This clause isn't just about defining jurisdiction, it's about India asserting its right to protect its digital sovereignty. It potentially leads or, struggles in a new era of digital international law, pushing the boundaries of traditional state sovereignty. It shifts the basis for jurisdiction from physical presence to virtual impact.
That's fascinating, a huge step into digital jurisdiction. So are there any limits? Does BNS override everything?
No, and that's where the final part of Section 1 comes in. Subsection 6 is a crucial savings clause. It explicitly states that the BNS will not affect military laws, such as those punishing mutiny and desertion of service personnel, nor will it affect the provisions of any special or local law.
Special or local law? Like what?
This is immensely important. It ensures that specialized legal regimes continue to operate within their designated spheres. Think of the Army Act or the Navy Act, or specific laws like the Protection of Children from Sexual Offenses Act, POCSO 2012, or the Narcotic Drugs and Psychotropic Substances Act, NDPS 1985. These remain untouched.
So POCSO cases are still handled under POCSO,
Yeah.
NDPS, under NDPS.
Correct. This adheres to a very important legal principle. Generally, specialibus non-derogant general provisions do not derogate from special ones. It ensures harmonious construction with other statutes. For example, if a person commits an offense exclusively defined and punishable under a state's local excise law, that local law would apply, and the BNS generally wouldn't override it. It prevents legal chaos by clearly carving out exceptions where specialized laws are already effectively dealing with specific issues.
Okay, that makes sense. Preserves specialized systems. So looking at Section 1 overall.
Taken as a whole, Section 1 is predominantly a declaratory and enabling provision. It defines the temporal scope, the commencement date, the nominal scope, the short title, and the jurisdictional scope, both intra- and extraterritorial. Its object, as we said, is to provide a clear and unambiguous framework for the Sanhita's identity, its operation, and the limits of its legal authority over persons, acts, and territories.
It's truly a complex web of rules just for determining who falls under the Sanhita's shadow and where. It's a reminder that jurisdiction isn't just some dry legal term, but a constantly evolving concept, especially now with digital borders.
Indeed. The salient features of Section 1 really include that clarity in naming, the flexible commencement we saw with the July 1st notification, comprehensive intraterritorial jurisdiction, a robust extraterritorial jurisdiction, particularly that forward-looking inclusion for cybercrime, which, as we discussed, has profound implications.
Definitely.
The principle of legality reinforced, and that vital savings clause that preserves the domain of military, special, and local laws.
Are there any existing legal principles or cases that kind of foreshadowed this, even if the BNS is new?
Absolutely. While the BNS is new, the principles it codifies often aren't entirely novel. On territorial jurisdiction and reaching outside, the old case of Mubarak Ali Ahmed v. State of Bombay established, even under the IPC, that an individual could be tried in India even if not physically present, provided there was a sufficient nexus, a connection, with India. Section 1.5c of the BNS now explicitly codifies such a nexus for cybercrimes targeting Indian resources, effectively bringing that older principle into the digital age.
Adapting old principles to new tech.
Exactly. And for savings clauses, the Supreme Court, for instance, in Union of India v. GS Chhatha Rice Mills, reinforced that such clauses must be given their full effect to ensure harmonious construction between different laws. It's about making sure the legal system works together coherently.
And the legal maxims you mentioned.
Yes, several apply here. Lex loci delicti commissi. The law of the place where the crime is committed is the primary rule for territorial jurisdiction under Section 1.3. The nationality principle is crystal clear in Section 1.5. The protective principle or effects doctrine, where a state has jurisdiction over acts committed abroad that detrimentally affect its interests, is specifically embodied in Section 1.5c concerning computer resources located in India. And of course, generalia specialibus non-derogant is fundamental to the savings clause in Section 1.6. Comes with the territory. As Chief Justice Marshall articulated way back in an American case, Schooner Exchange v. McFadden, the jurisdiction of the nation within its own territory is necessarily exclusive and absolute. Section 1.3 reflects this core idea, while Sections 1.4 and 1.5 demonstrate the recognized extensions and exceptions to this exclusivity that are necessary in a modern, globalized, and digital world. In essence, Section 1 of the BNS, 2023, meticulously defines the Sanhita's operational parameters. It balances national sovereignty in criminal matters with the imperative to address transnational crimes and protect national interests, including in the digital domain, all while respecting specialized legislation. It's fundamental to the rule of law and the fair administration of criminal justice in India.
Absolutely foundational.
So now that we know where the law applies and to whom it applies, it becomes absolutely essential to understand what the law means by its own terms. We need to look at its lexicon, the very words it chooses to define.
The Lexicon of Justice, Section 2.
That's a critical point. In any intricate system, especially one as precise as the law must aim to be, the definitions aren't just, dry dictionary entries. They are, as you say, the lexicon of the Sanhita. They shape every single subsequent interpretation and application. Okay, let's unpack this. Section 2. It begins with a very important phrase. In the Sanhita, unless the context otherwise requires, that bit, unless the context otherwise requires. That already tells us there's a degree of flexibility built in here, right? It's not always rigidly fixed.
Absolutely. That introductory phrase is a standard but vital legislative device. It signifies that while the definitions provided are generally intended to be applied universally throughout the Sanhita, there's an inherent flexibility.
So it's not absolute.
No. It allows for a departure from these defined meanings if the specific context of a particular provision genuinely necessitates a different interpretation. This is essential for nuanced application in complex legal scenarios. The role and significance of a definition section like this cannot be overstated. It aims to ensure clarity, precision, and consistency in interpreting terms. It curtails ambiguity, promotes uniformity.
Which must make the law more predictable.
Exactly. It ultimately upholds the principle of legal certainty, which is fundamental to a predictable and fair justice system.
Okay, so Section 2, it looks pretty long. How many definitions are we talking about?
It's quite extensive, yes. Section 2 of the BNS 2023 contains 39 clauses, each defining a specific term. We obviously can't go through all of them in detail,
Right.
but we can focus on some key definitions that are particularly significant or perhaps illustrative of the Sanhita's modern approach, the ones that really give us an aha moment about the legislative intent behind the words.
Sounds good. Where should we start?
Let's start right at the beginning with Clause 1, Act. It states that the word act denotes as well a series of acts as a single act.
Okay, so act can mean more than one action.
Precisely. The core concept here is expansive. Criminal liability isn't confined to a singular, isolated action, but can encompass a whole sequence of actions over time.
Why is that important?
Well, it's crucial for complex offenses. Think about criminal conspiracy or ongoing fraud or prolonged abuse. Culpability in these cases often arises from multiple cumulative actions. Its object is clearly to prevent narrow interpretations that might allow someone to evade liability by claiming each individual step wasn't the complete crime. This definition forms the actus part, the physical act of the fundamental legal maxim we often hear. Actus non facit reum nisi mens sed rea.
The act doesn't make you guilty unless you have the guilty mind.
Exactly. This definition ensures the law can capture the full scope of a criminal enterprise or course of conduct, not just a single snapshot.
Got it. What's next? Something fundamental.
How about Clause 3, child? It simply defines child as any person below the age of 18 years.
18. That seems straightforward. Is it new?
The significance lies in establishing a uniform age threshold across the Sanhita. This is a crucial aha moment for consistency. It aligns India's primary criminal code with key international conventions, like the UN Convention on the Rights of the Child, and also with major domestic laws like the Juvenile Justice, Care and Protection of Children Act, and the POCSO Act.
So it brings the main criminal law in line with child protection laws.
Correct. This definition is critical in several contexts. Firstly, for determining criminal capacity. Sections 20 and 21 of BNS deal with a child's ability to form criminal intent based on age. Secondly, for the applicability of specific offenses where the victim's age is an element, for example, Section 63 concerning rape, or other provisions involving exploitation or harm to minors. The straightforward nature simplifies age determination across the Sanhita, removing potential previous ambiguities that might have existed from different age thresholds scattered across various older laws.
That alignment with international standards and domestic laws seems really crucial for consistency. It simplifies things internally within the BNS, but does this uniform age threshold of 18 truly simplify things across all related laws? Or are there still areas where age definitions might create a kind of legislative gray area for, say, specific types of offenses or maybe legal responsibilities outside the Sanhita's direct scope?
That's a very astute observation, and it really highlights a persistent challenge in legal harmonization. While the BNS certainly brings internal consistency, which is a major step forward, the broader landscape of Indian law is, as you know, vast and complex.
Right.
So, for instance, the age for contractual capacity or the legal age for consuming alcohol might still vary under different state laws or special statutes. So while child within the BNS is consistently defined as below 18, it doesn't automatically mean all other legal consequences tied to age across the entire Indian legal system are suddenly unified.
Okay, so it fixes it for criminal law under BNS, but not necessarily everywhere else.
Precisely. The goal here is specific to criminal liability and victim protection within the Sanhita itself, which is a significant achievement. But those larger legislative gray areas you mentioned often require continuous statutory review and amendment across different domains of law. Harmonization is an ongoing process.
Understood. What about definitions reflecting, say, technological changes?
Ah, yes. A very forward-looking definition and another real aha moment for modernity is Clause 8. Document. Listen to this. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, and includes electronic and digital record, intended to be used as evidence of that matter.
Includes electronic and digital record. That sounds important.
Hugely important. The core concept is a broad, explicitly technology-neutral meaning. Its basic ingredients are some expression of matter on any substance, paper, stone, silicon chip, using letters, figures, marks, or similar means, the explicit inclusion of electronic and digital records, and the intention for it to be used as evidence.
So an email can be a document, a database entry.
Absolutely. The scope is significantly widened by this explicit technology inclusion. It's crucial for prosecuting cybercrimes, dealing with digital evidence. Think about offenses like forgery. You can forge a digital signature, right? Or any crime where digital records, logs, messages, financial transactions play a role. This definition aligns seamlessly with the Information Technology Act 2000.
So it updates the very idea of what constitutes evidence.
Exactly. The illustrations provided in the old code, which are usually carried forward implicitly, included things like a contract, a check, a map, even writing giving directions, all are documents. This definition ensures that concept extends naturally into the digital realm. It silently revolutionizes how evidence is perceived and handled in the legal system.
What about definitions related to people, identity?
Yes, Clause 10. Gender is profoundly important here. It states the pronoun he and its derivatives are used of any person, whether male, female, or transgender.
Okay, he includes male, female, or transgender.
Correct. This promotes gender inclusivity, ensuring the equal application of the law irrespective of a person's gender identity. It explicitly includes transgender, and even cross-references the Transgender Persons Protection of Rights Act, 2019, for further clarity. This reflects the principles laid down by the Supreme Court in the landmark Nellis v. Union of India case back in 2014, which recognized the fundamental rights of transgender persons.
So this embeds that recognition directly into the main criminal code.
Yes. It's a significant step towards a more inclusive criminal law framework. This directly impacts the interpretation of virtually all provisions that might traditionally use masculine pronouns, ensuring they apply universally across the gender spectrum recognized by law. It's a clear move away from outdated binary gender assumptions in legal drafting.
So a simple pronoun definition carries a massive statement about equality and recognition within the justice system. That's a powerful and, frankly, much-needed modernization.
Absolutely. It's subtle textually, but profound in its implication. Then, let's look at Clause 11. Good faith. This is another foundational definition, often misunderstood. It says, nothing is said to be done or believed in good faith, which is done or believed without due care and attention.
Without due care and attention. So it's not just about being honest.
Exactly. This is a negative definition and a subtle aha moment about the standard required.
Yeah.
It sets a higher bar than just subjective honesty. It demands honesty coupled with objective due care and attention.
So you have to be careful, not just sincere.
Precisely. It's crucial for many of the general exceptions. The defenses found in Chapter 3, things like acts done by judges, acts done under legal compulsion, acts done for a person's benefit without consent in emergencies. Sections 14, 15, 17, 19, 26, 27, 30, 31 of BNS all rely on this. This definition prevents the defense of good faith from being claimed by those who act negligently or recklessly. Judicial interpretation generally applies the standard of a reasonable and prudent person under the given circumstances. It's not enough to think you're doing the right thing. You have to have acted with reasonable diligence as well.
So good faith isn't just about having a pure heart, it's about having a careful mind, too. Sounds like a good rule for, well, online interactions as well as criminal law, wouldn't you say?
Agrees. Indeed, it's a principle with broad applicability, isn't it? Highlighting that intentions, however good, must be backed by responsible action.
Okay. What about the definition of offense itself? Seems pretty basic, but maybe there's more to it.
There is, actually. Clause 24. Offense provides a general meaning, but also specifies tiered meanings for specific contexts, particularly concerning its relationship with those special and local laws we mentioned earlier under Section 1.6.
Tiered meanings, how does that work?
Generally, offense just means a thing made punishable by this Sanhita, the BNS. Simple enough. However, for certain parts of the BNS, specifically Chapter 3, General Exceptions, and a long list of specific sections enumerated within the definition itself, offense also includes acts punishable under any special law or local law.
So the BNS defenses can apply even if the crime is defined elsewhere.
In those specific contexts, yes. And then there's a second tier. For another set of specified sections, offense includes acts punishable under special or local laws, but only if they carry a punishment of imprisonment for 6 months or more.
Wow, okay. That's quite specific. Why the complexity?
This tiered definition is crucial for determining the jurisdictional reach of certain BNS principles, like the general exceptions, self-defense, necessity, etc., when the primary act itself is defined and punished under a different statute, like POCSO or NDPS. It ensures a degree of harmony and consistency, making sure fundamental defenses are available where appropriate, while still respecting the principle of generalia specialibus non derogant, that special laws prevail in their specific domain. It prevents the BNS from creating unnecessary conflicts, instead allowing it to act as a supportive foundational framework for the broader criminal justice system.
That's intricate, but it sounds like it's designed to make different laws work together better.
That's the aim. Let's briefly touch on a couple of others. Clause 28, public servant. This provides an extensive, inclusive list, identifying individuals in positions of public trust and responsibility.
Who does that cover?
It covers a wide range. Commissioned officers in the armed forces, judges, officers of the court, jurors, arbitrators, government officers, officials involved in the electoral process, employees of government companies, and so on. The explanations further broaden this, including persons who are in de facto possession of the situation of a public servant, even if there were legal defects in their right to hold that position.
So even if their appointment wasn't technically perfect, if they're acting as one.
It can still be considered one for the purposes of the law. This definition is crucial for offenses committed by or against public servants, which are detailed in Chapter 12 of the BNS, and also for understanding limitations on the right of private defense against acts of public servants under Section 37(1)(a). Judicial interpretation often uses a functional test. Does the person perform a public duty, and are they vested with some form of public authority?
Right, and you mentioned borrowing definitions.
Yes, finally, Clause 39, reference definitions. This is just efficient legislative drafting. It states that words and expressions used but not defined in this Sanhita, but defined in the Information Technology Act 2000 and the Bhartiya Nyaya Sanhita 2023, BNSS, shall have the meanings respectively assigned to them in that act and Sanhita.
So it imports definitions from the IT Act and a new procedural code, BNSS.
Exactly. It avoids redundancy and ensures harmonious interpretation across these closely interconnected laws. For example, for technical terms like computer resource from the IT Act or procedural terms from the BNSS, you look to those acts. It's a pragmatic approach to maintaining consistency across the legal ecosystem.
Makes sense. Don't reinvent the wheel.
Precisely. And of course, there are other key definitions we haven't explored in depth. Animal, death, dishonestly, fraudulently, injury, illegal, omission, person, special law, local law, voluntarily, wrongful gain, wrongful loss. Each plays a vital role in precisely defining the elements of various crimes and defenses throughout the Samhita.
A whole vocabulary just in Section 2.
Indeed. So with the language now clearer, the actual lexicon established, let's explore the fundamental rules that govern how these definitions apply and the very nature of criminal liability itself. This is where the machinery of justice really starts to move, based on these defined terms.
The Rule Book of Liability, Section 3, General Explanations.
Okay, let's unpack this. We've established the foundational language of the BNS through its definitions in Section 2. Now, Section 3, titled General Explanations, introduces what I think of as the deep operating rules, the principles that permeate the entire Sanhita. These aren't just footnotes. They seem like the overarching interpretive rules for understanding offenses and liability. This is where it gets really interesting, as these principles shape everything that follows and often contain subtle but powerful legal ideas, sometimes even legal fictions.
Precisely. Section 3 is exactly that, a set of overarching interpretative rules and fundamental principles of criminal liability that apply throughout the Sanhita. Its core concept is to ensure consistency, prevent ambiguity, and codify well-established tenets of criminal law. Its object is to guide the uniform construction and application of the Sanhita's provisions. It's like the user manual, the operating system for the rest of the code.
The OS for the BNS. I like it. So what are the key rules here?
Let's break down these crucial subsections. Subsection 1 is absolutely cardinal, a foundational aha moment for understanding the entire code. It says, throughout the Sanhita, every definition of an offense, every penal provision, and every illustration shall be understood subject to the exceptions contained in the chapter entitled General Exceptions, though those exceptions are not repeated in such definition.
Whoa. So Chapter 3, the general exceptions or defenses, applies to everything, even if it's not explicitly mentioned.
Everything. Every single offense, every punishment, every example. Chapter 3, sections 14 through 44, which deals with general defenses like infancy, mistake of fact, accident, necessity, unsoundness of mind, intoxication, consent, self-defense, is implicitly woven into every single offense definition.
Give me an example.
Okay. The BNS definition of theft doesn't explicitly say unless committed by a child under 7. But the definition of theft is always understood subject to Section 20 of the BNS, which provides that nothing done by a child under 7 years of age is an offense.
Ah, okay. It's automatically built in.
Automatically. Similarly, a police officer lawfully arresting a murderer isn't guilty of wrongful confinement thanks to Section 14, which exempts acts done by persons who are bound or justified by law. This principle is imperative, it's universal within the BNS, and it ensures fairness by always considering available general defenses. It also saves countless repetitions of these defenses throughout the hundreds of specific crime definitions.
It's incredibly efficient and important for fairness. What's next?
Subsection 2 provides for the uniformity of explained expressions. It simply states that every expression which is explained in any part of the Sanhita is used in every part of the Sanhita in conformity with the explanation.
So once a word is defined in Section 2, it means the same thing everywhere else in the BNS.
Exactly. It holds that meaning consistently throughout the entire Sanhita. This promotes clarity and predictability, avoiding different meanings for the same term cropping up in different chapters, unless, of course, the context explicitly demands otherwise, which is that caveat we saw in Section 2's opening phrase. Generally, though, one definition, one meaning.
Consistency. Got it. What about subsection 3, possession?
Ah, yes. Subsection 3 introduces a crucial legal fiction, constructive possession. It says, when property is in the possession of a person's spouse, clerk, or servant on account of that person, it is in that person's possession within the meaning of this Sanhita. The explanation clarifies that even temporary or occasional employees fall under clerk or servant.
So if my employee holds something for me, legally I possess it.
On your account, yes. This is vital for property offenses like theft, criminal misappropriation, criminal breach of trust. It prevents offenders from evading liability by simply using intermediaries to hold the goods or money. Imagine a shop owner. The goods in the hands of their cashier, held on the owner's behalf, are legally considered to be in the owner's possession for the purpose of theft by, say, a customer.
Right.
This provision simplifies prosecution and ensures accountability even when direct physical possession is absent. It's an aha moment for understanding how the law expands traditional notions of possession to prevent easy loopholes. It reflects commercial and social realities.
Makes sense. What about acts versus omissions?
Subsection 4 clarifies that relationship. Acts include illegal omissions. It states, words which refer to acts done extend also to illegal omissions, unless the context suggests otherwise.
We saw omission defined earlier, so this confirms liability can arise from not acting.
Precisely. It broadens the concept of criminal conduct, ensuring that culpable failures to act, where there is a legal duty to act, as defined in Section 215 under illegal and legally bound to do, are also punishable. It reflects that liability can arise just as much from wrongful commissions as from wrongful omissions. For example, a parent who deliberately withholds food from their infant child, leading to the child's death, is liable not just for the act of starvation, but for the illegal omission of failing in their legal duty to provide sustenance.
So it's not just about what you do, but sometimes critically about what you fail to do when you have a legal obligation.
Yeah.
That's a significant basis for culpability.
Absolutely. This principle is fundamental to many offenses. Then, subsection 5 codifies common intention, a cornerstone concept of joint liability in criminal law.
Common intention, like planning a crime together.
Essentially, yes, it states, when a criminal act is done by several persons in furtherance of the common intention of all, each of the such persons is liable for that act in the same manner as if it were done by him alone. This applies when there's a prearranged plan, a prior meeting of minds, or shared purpose among multiple individuals before or during the commission of the crime.
So everyone involved is equally guilty of the final act.
Yes, all participants in such a joint criminal enterprise are held equally liable for the criminal act committed in furtherance of that shared intention, regardless of the specific role each one played. If A and B plan to rob C, and A stands guard while B actually takes the money, both are guilty of robbery because they acted in furtherance of their common intention. This is analogous to the well-known Section 34 of the old Indian Penal Code.
Are there famous cases on this?
Oh, many. Landmark cases like Mahbub Shah v. Emperor and Pandurang, Tukia and Bilia v. State of Hyderabad from the Privy Council and Supreme Court respectively, extensively clarified that common intention requires this element of pre-concert, a shared plan, distinguishing it sharply from mere similar intention, where people might happen to have the same idea independently. It's an aha moment about how a shared criminal goal can bind individual actions into collective, equal liability.
Okay, common intention needs a plan. What about similar intention? Is that covered too?
Yes, that brings us neatly to subsection 6 on similar intention knowledge. This deals with joint liability in a slightly different scenario. It covers situations where an act, which is criminal only by reason of its being done with a criminal knowledge or intention, is done by several persons. Each of such persons who joins in the act with such knowledge or intention is liable for the act in the same manner as if the act were done by him alone with that knowledge or intention.
How is that different from common intention?
This is similar to Section 35 of the old IPC. The crucial distinction from subsection 5 is that this doesn't necessarily require a prearranged plan or pre-concert for the specific outcome. It focuses on the individual mens rea, the criminal intent or knowledge of each participant at the moment they join in the criminal act.
So no prior meeting of minds needed.
Not necessarily for the specific act. For instance, if two individuals, unknown to each other, both see an opportunity to loot a shop during a riot, and both independently decide to break in and steal, each acting with the similar intention to commit theft, they would each be liable for their actions potentially under the section based on their individual intent, even if they didn't coordinate beforehand. The key is their individual mental state aligning with the criminal act they participate in.
So subsection 5 is about teamwork with a pre-plan, and subsection 6 is more about individual bad intentions happening to converge on the same criminal act without necessarily coordinating. It's a subtle but critical distinction for assigning guilt, kind of separating a planned gang operation from two independent vandals hitting the same wall.
Precisely. That's an excellent way to distinguish them. It's about the nuanced gradations of collective responsibility and individual culpability.
What else does section 3 cover?
Subsection 7 addresses offenses caused partly by act and partly by omission. It clarifies that if an offense can be caused by either an act or an illegal omission, it can also be committed by a combination of both. The illustration provided in the older codes, usually considered indicative, is clear. A intentionally causes Z's death, partly by illegally omitting to give Z food, and partly by beating Z. This combination constitutes murder. This ensures comprehensive liability, reflecting the real-world complexity of how harm can often be inflicted through a mix of actions and failures to act.
Right, life isn't always neat categories.
Exactly. Then subsection 8 deals with cooperation in offense committed by several acts. This is interesting. It says if an offense involves several acts, anyone who intentionally cooperates by doing any one of those acts, either singly or jointly with others, commits the offense.
So if a crime needs multiple steps, contributing to just one step intentionally makes you guilty of the whole crime.
If you are intentionally cooperating towards the commission of that offense, yes. It establishes liability for individuals who contribute to an offense through cooperative acts, even if they don't perform every single part themselves. For instance, the classic example, A and B agree to murder Z by giving small, separate doses of poison over time. A gives one dose, B gives another later. Z dies from the cumulative effect. Both A and B are guilty of murder because they intentionally cooperated in the commission of the offense through their respective acts.
Even if neither dose alone would have killed Z.
Correct, because they were cooperating towards that end result. Another example often used. A and B are jailers responsible for Z. A, intending to cause Z's death, illegally omits to supply Z with food. B, independently but also intending Z's death, illegally omits to supply Z with water. Z dies of hunger and thirst. Even if they didn't explicitly plan together, their intentional cooperation through omissions, if proven they knew of each other's actions and cooperated towards the same end, could make both guilty under principles related to this section. Or even simpler illustrations show joint liability when different jailers in sequence contribute to starvation leading to death.
Wow, that covers a lot of ground for complicity. Is there anything else in section 3?
Yes, one final, very important principle in subsection 9. It allows for different offenses from the same criminal act. It states where several persons are engaged or concerned in the commission of a criminal act, they may be guilty of different offenses by means of that act.
Wait, same act, but different crimes. How?
This is a crucial principle ensuring individualized culpability. It depends on the individual mens rea or circumstances of each participant. For example, imagine A attacks Z under grave and sudden provocation. His killing of Z might only amount to culpable homicide, not amounting to murder. But if B, who harbors long-standing ill will towards Z and has a clear intention to kill him, assists A in the attack without having received any provocation himself, B could be guilty of murder, while A is guilty of the lesser offense of culpable homicide.
Because B had the murderous intent, and A didn't, even though they were involved in the same fatal assault.
Exactly. This upholds the fundamental principle that criminal liability is personal, based on one's own mental state and circumstances, even when acts are performed jointly.
That's a critical nuance for fairness.
Absolutely. So, in summary, Section 3 acts as an indispensable internal guide to interpreting and applying the BNS. It codifies fundamental principles of criminal liability, including joint liability, common intention, similar intention, cooperation, and constructive liability, possession, omissions, ensures the universal application of general defenses from Chapter 3, clarifies the relationship between acts, omissions, and, critically, recognizes that participants in the same criminal act can have differing degrees of culpability leading to different offenses. It's the engine room of liability assessment.
It's truly a comprehensive rulebook for understanding how culpability is assigned under the new Sanhita. With criminal acts and liability clearly defined by these rules and definitions, our next logical step has to be exploring the consequences for those found guilty. What happens next?
The Scales of Justice, Section 4.
Indeed. Once we understand what constitutes an offense and who is liable under these intricate rules, the natural question becomes, what are the consequences? We're now turning to what many consider the heart of criminal law, punishments. So what does this all mean for shaping accountability under the BNS? Let's introduce Section 4, which actually lists the various types of punishments the courts can impose.
Exactly. Section 4 of the Bhartiya Nyaya Sanhita 2023 meticulously enumerates the legally sanctioned punishments that can be imposed upon conviction for offenses defined within the Sanhita. Its core concept is really to define the full spectrum of punitive measures available to the courts.
The menu of options, so to speak.
In a way, yes. And these serve various aims of criminal justice, retribution, deterrence, reform, incapacitation. It's the concrete expression of society's response when a crime has been proven.
Okay, so what's on the menu? What are the types of punishments listed in Section 4?
The basic ingredients or types of punishments laid out are: first, death. This remains the most severe punishment available under Indian law, typically reserved by judicial precedent for the rarest of rare cases. Its inclusion signifies the gravity with which the law views certain exceptionally heinous offenses.
Still there. The ultimate penalty.
Yes. Second, imprisonment for life. It's important to note this generally means imprisonment for the natural life of the convict, subject, of course, to provisions for remission or commutation by the appropriate government, which we'll touch upon later.
So life means life, unless commuted.
That's the default legal position established by courts. Third, imprisonment, which itself is of two descriptions: rigorous, which involves an obligation to perform hard labor as prescribed by prison rules, and simple, which does not involve hard labor. This allows for a differentiation in the nature of incarceration based on the severity of the crime and perhaps the character of the offender.
Rigorous or simple?
Fourth, forfeiture of property, which involves the state taking ownership of specific property connected to the offense or the offender, often proceeds of crime or instrumentalities used in the crime. Fifth, fine, which is a monetary penalty imposed on the offender.
Standard stuff so far.
Yeah.
Death, life, jail time, losing property, paying money, anything new?
Yes, and this is a truly noteworthy addition, a genuine aha moment perhaps for modern penology in India: community service.
Community service as a formal punishment.
Yes, listed right there in Section 4. This is a novel and, I would argue, significant and progressive addition to the general list of punishments applicable under the Sanhita. It clearly reflects a modern approach to penology, actively moving towards considering reformative and non-custodial options where appropriate.
What does it involve?
Community service typically requires the offender to perform unpaid work for the benefit of the community for a specified number of hours. It's often considered suitable for less serious offenses or perhaps first-time offenders. For example, if you look at specific sections within the BNS, like the proviso to Section 3032 dealing with certain forms of petty theft, or Section 3562 dealing with punishment for defamation, they explicitly mention community service as a potential punishment the court can impose.
So it's actually written into specific offenses as an option.
Yes. Its inclusion in the main list in Section 4 acknowledges that sometimes a prison sentence isn't the most effective, proportionate, or appropriate response. It offers an alternative focused on reparation and reintegration.
The inclusion of community service really feels like a potential paradigm shift, doesn't it? It suggests a move towards maybe rehabilitation and restorative justice rather than purely punitive measures for certain offenses. It's almost saying, how can you give back to society instead of just being removed from it?
Exactly. It's a very clear signal of that philosophical shift, at least in principle. The nature of Section 4 itself is enumerative. It lists the options, and prescriptive. It dictates these are the permissible punishments. Its scope applies to all offenses under the BNS for which these punishments are specified in the relevant sections.
And the key features.
The salient features clearly include the retention of traditional punishments, death, life imprisonment, rigorous or simple imprisonment, forfeiture, and fine, which carry over continuity from the previous penal system. However, the standout feature is undoubtedly the formal introduction of community service into the primary penal code's sentencing toolkit. This aligns India's criminal justice system, at least legislatively, with global trends towards alternative sentencing and a more nuanced, potentially more effective approach to justice for certain types of cases.
How does this relate to legal principles or theories of punishment?
Well, firstly, Section 4 adheres fundamentally to the principle of nulla poena sine lex, no punishment without law, by clearly listing the legally permissible punishments. No court can invent a punishment not listed here or specified for the offense. Secondly, the actual awarding of punishment by a judge is generally guided by the principle of proportionality in sentencing, ensuring the punishment fits the gravity of the crime and the culpability of the offender.
Making the punishment fit the crime.
Exactly. And listed punishments reflect various underlying theories of punishment. Death and imprisonment serve deterrence, discouraging others, and incapacitation, preventing the offender from reoffending. Retribution, society's moral condemnation, is reflected in most punishments. And significantly, community service and perhaps simpler forms of imprisonment or fines in some contexts clearly lean towards reformation, rehabilitation, and potentially restitution, making amends.
So it's a mix of philosophies.
Yes. As the Italian jurist Cesare Beccaria famously argued centuries ago in Crimes and Punishments, for a punishment to attain its end, the evil which it inflicts has only to exceed the advantage derivable from the crime. While deterrence is key, the introduction of community service demonstrates a clear legislative intent to provide courts with options that also prioritize a more balanced, potentially rehabilitative justice system where appropriate.
Modifying sentences, Section 5. Commutation of sentence.
That's a great point about balancing punitive and rehabilitative goals. But even after a sentence is handed down by the court, the law often provides mechanisms for modification, right? It's not always the final word. So let's look at Section 5, which discusses the commutation of a sentence. What exactly does that entail, and how does it fit into the broader scheme of justice? Is it like an appeal?
Not exactly like an appeal, which is a judicial process reviewing the conviction or sentence itself. Section 5 deals with the executive power to modify or reduce a judicially imposed sentence. Its core concept is to provide a mechanism for clemency or mercy exercised by the government.
Clemency. Okay. Why have this power?
It serves several purposes. It can be used for correcting potential judicial errors that may not be easily rectifiable through the normal appellate process, perhaps due to procedural limitations. It can also be used to grant relief based on post-sentencing factors, maybe the offender's conduct in prison, serious illness, or other humanitarian grounds. And importantly, this power can be exercised without needing the offender's consent. It's an act of mercy, an exercise of sovereign power vested in the executive branch.
So who holds this power?
The basic ingredients are the power to commute, meaning substitute a sentence with a less severe one, the fact that no consent is needed from the offender, it's a state prerogative, and importantly, Section 5.2 states that this process must be carried out in accordance with the procedure laid down in Section 474 of the Bhartiya Nyaya Sanhita 2023, BNSS. This highlights the essential linkage between the substantive power in BNS and the procedural rules in BNSS.
Okay, procedural rules apply. But which government, central or state?
Section 5 clarifies the appropriate government for commutation. It's the central government in two cases: for death sentences and for offenses against laws where the union's executive power extends. In other cases, where the offense relates to a matter to which the state's executive power extends, which covers most common crimes, the power lies with the government of the state within which the offender is sentenced. This applies even if the sentence imposed by the state court was death.
So, state governments handle commutation for most state-level crimes. Does this relate to the president's and governor's pardoning powers?
Yes, absolutely. This power, while codified here in the BNS, connects directly to the broader constitutional clemency powers granted to the President of India under Article 72 and to the state governors under Article 161 of the Constitution. Those constitutional powers are typically considered wider, encompassing pardons, reprieves, respites, remissions, as well as commutation. Section 5 specifically operationalizes the statutory aspect of commutation within the framework of the new criminal codes.
Can this power be challenged if someone thinks the government commuted a sentence unfairly?
That's a crucial point. While clemency is largely an executive prerogative, it's not entirely immune from judicial review. The Supreme Court, in cases like Maru Ram v. Union of India and later Ipuru Sudhakar v. Godav of AP, has established that the exercise of clemency powers can be subject to judicial review on limited grounds, such as arbitrariness, malifides, bad faith, or if relevant factors weren't considered or irrelevant factors were considered. So there's a delicate balance of powers and aha moment about the tension between executive mercy and judicial oversight ensuring fairness.
So it's an executive power linked to the Constitution, but not completely unchecked.
Exactly. This is an aspect of prerogative power, an executive function that balances the judicial role in sentencing, contributing to the broader system of checks and balances inherent in India's constitutional structure.
Precision and flexibility in sentencing, sections 6 and 7.
That's a really important aspect of the system, that executive check. Moving on, let's discuss the practicalities of calculating and defining imprisonment itself. How does the BNS ensure precision, especially when dealing with fractions, and also flexibility in the type of imprisonment? Let's introduce Section 6, which deals with fractions of punishment, and Section 7, covering whether imprisonment is rigorous or simple.
Right. These sections deal with the nuts and bolts of sentencing calculations and descriptions. For calculations involving fractions, Section 6 provides a specific practical rule. It's essentially a crucial legal fiction. It states, in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years unless otherwise provided.
Wait, life imprisonment equals 20 years. I thought you said it means natural life.
Good catch. This is where the legal fiction part comes in. The core concept here is not redefining life imprisonment itself. It remains, as established by the Supreme Court in cases like Gopal Vinayak Godse v. State of Maharashtra, imprisonment for the natural life of the convict. Section 6 is only for the specific purpose of calculating fractions.
Okay. Why would you need to calculate a fraction of a life sentence?
For various administrative and legal purposes. For example, determining eligibility for remission or parole might involve calculating a fraction of the sentence served. Or, if someone is sentenced concurrently for multiple offenses, one carrying life and others carrying fixed terms, you might need a numerical equivalent for life for certain calculations. The primary object of Section 6 is simply to bring certainty and uniformity to these specific calculations by providing a standard benchmark, 20 years.
So it's just a math tool, not a change in the life sentence meaning.
Precisely. And the phrase, unless otherwise provided, embodies that principle we discussed. Lex specialis derogat legi generali. A special law derogates from a general law. If another specific law or rule provides a different method for calculating a fraction of a life sentence in a particular context, that special rule would prevail over this general BNS rule. It's an aha moment to clearly distinguish between the legal reality of life imprisonment, natural life, and this specific legal fiction used only for practical administrative calculations.
Got it. 20 years for math purposes only. What about Section 7? Rigorous versus simple.
Section 7 addresses the description of imprisonment. It states that in cases where an offender is punishable with imprisonment, the court may sentence the offender, wholly or partly rigorous or simple. This grants significant judicial discretion.
So the judge decides the type of jail time.
Yes, in cases where the specific offense allows for imprisonment of either description, meaning the law defining the crime says the punishment can be rigorous or simple, the court has the flexibility to direct that the imprisonment be wholly rigorous or wholly simple, or even partly rigorous and partly simple.
Why have that flexibility?
It allows for a nuanced application of punishment. The court can tailor the sentence to the specific circumstances of the case, the nature of the crime, and the character of the offender. It allows for balancing punitive goals with potential reformative aspects. For example, a court might impose an initial period of rigorous imprisonment to emphasize the punitive element, followed by a period of simple imprisonment, perhaps to focus more on rehabilitation or prepare for release. This flexibility is a salient feature, underscoring the trust placed in the judiciary to craft appropriate and proportionate sentences, rather than imposing a rigid one-size-fits-all approach for all cases falling under a particular section.
The nuances of fine, Section 8. Amount, default, and recovery.
Fines are such a common form of punishment, probably the most common after imprisonment itself, yet their rules can be quite complex, as you mentioned. It sounds like the BNS 2023 has laid out a pretty comprehensive framework for them in Section 8. So let's explore that. How does it regulate fines? How does it ensure fairness but also make sure they're actually paid?
Section 8 is indeed a comprehensive framework, yes. It meticulously regulates the imposition of monetary penalties, or fines. Its core concept is to establish rules covering the amount, the consequences of non-payment, default, and the methods of recovery, all while trying to ensure fairness and effectiveness.
Okay, let's break down the subsections. What about the amount? Can courts impose any fine they want?
Subsection 1 deals with the amount of fine specifically when the law defining the offense doesn't express a specific limit on the fine amount. In such cases, it states that the amount of fine is technically unlimited, but, and this is crucial, it shall not be excessive.
Unlimited but not excessive? How does that work?
It grants wide judicial discretion, but couples it with a vital safeguard against arbitrary or disproportionate fines. What constitutes excessive isn't defined rigidly, but is generally interpreted by courts, considering factors like the gravity of the offense, the financial circumstances of the offender, their capacity to pay, and the overall proportionality of the sentence. It's a check on potentially ruinous financial penalties.
Okay, so there's a reasonableness check. What happens if someone just doesn't pay the fine?
That's addressed in subsection 2, which covers imprisonment in default of payment. If a fine is imposed, whether it's the only punishment or imposed alongside imprisonment, the court can direct that the offender serve a term of imprisonment if the fine isn't paid. Importantly, this default imprisonment is in excess of any other substantive imprisonment ordered for the offense.
So it's extra jail time specifically for not paying the fine?
Correct. Its object is purely as an enforcement mechanism, a way to compel payment and ensure that fines aren't rendered ineffective. It prevents offenders from simply opting out of the financial penalty without consequence.
Is there a limit on how long this default imprisonment can be?
Yes, there are limits. Subsection 3 places a specific limit on this default imprisonment for offenses that are punishable with both imprisonment and fine. In such cases, the default term of imprisonment cannot exceed 1/4 of the maximum term of imprisonment fixed for that substantive offense. This ensures a degree of proportionality and prevents the sentence for non-payment from overshadowing the punishment for the actual crime itself.
1/4 of the max jail term.
Got it.
Right.
What kind of imprisonment is it? Rigorous? Simple?
Subsection 4 dictates the description of the default imprisonment. It states it can be of any description, rigorous or simple, to which the offender might have been sentenced for the main offense. So if the main offense allowed rigorous imprisonment, the default term could also be rigorous.
But crucially, this subsection now explicitly includes a reference to imprisonment in default of community service. This directly links the default mechanism to the new punishment introduced in Section 4 and strengthens its enforceability. This is an important modernization, ensuring community service isn't just a suggestion, but carries a real legal consequence if not performed or complied with, similar to non-payment of a fine.
So you could get jail time for not doing your community service.
Potentially, yes, under these provisions. Then, subsection 5 covers the scenario where the offense is punishable only with a fine or only with community service. In these less serious cases, the default imprisonment must be simple imprisonment.
Only simple jail time for defaulting on just a fine or community service.
Correct. And specific caps are set based on the fine amount. A maximum of 2 months default imprisonment for fines up to $5,000, a maximum of 4 months for fines between $5,001 and $10,000, and a maximum of 1 year for fines exceeding $1,000. This ensures less severe default penalties for what were originally considered less serious offenses, respecting the initial gravity assessment.
That tiered approach makes sense. What if someone starts paying the fine after they've already started serving the default time?
That brings us to subsection 6, which is particularly interesting and practical. It allows for the termination of default imprisonment upon payment of the fine. Not only does the default imprisonment end entirely if the full fine is paid or legally levied,
Right.
but Part B introduces a proportionality rule. If a proportion of the fine is paid or levied before the full term of default imprisonment expires, the imprisonment term is reduced proportionally.
So paying part of the fine reduces the jail time accordingly.
Exactly. The illustration often used is helpful. If someone, let's call him A, is sentenced to pay a $1,000 fine and, in default, to serve 4 months imprisonment. If 754, 3/4 of the fine, is paid or levied within the first month of imprisonment, A must be discharged as soon as that first month expires, because they only need to serve 1/4 of the default term, 1 month, corresponding to the unpaid 1/4 of the fine. This rule encourages payment even after default imprisonment has begun and reflects a very practical and arguably fair approach to recovery. It's not an all-or-nothing situation.
That's a clever mechanism. How long does the state have to collect the fine? Does it expire?
Finally, subsection 7 covers the levy or recovery of the fine. It specifies a time limit. Fines can generally be levied any time within 6 years after the sentence is passed. However, if the offender is liable under the sentence to imprisonment for a period longer than 6 years, then the fine can be levied any time before the expiration of that longer period.
Okay, 6 years or the length of the sentence, whichever is longer. What if the offender dies? Is the fine wiped out?
No. And here's a crucial detail often overlooked. The offender's death does not discharge from the liability any property that would, after their death, be legally liable for their debts.
Wow. So the government can still go after the offender's estate to recover the fine?
Yes. This is the long arm of the law, ensuring that the financial penalty isn't automatically extinguished by death, enhancing enforceability, and preventing evasion simply by passing away before the fine is collected. The liability attaches to the estate.
That's quite something.
Indeed. So the salient features of Section 8 include its careful balance between judicial discretion, unlimited but not excessive fines, and legislative limits, caps on default terms. Its modernization by explicitly including default for community service, its emphasis on proportionality, default term limits, reduction on part payment, the significant extension of liability to the offender's estate, and that crucial not excessive safeguard. It operates under the principle that default imprisonment isn't punishment for the original crime again that would violate principles like nemo debet bis vexari pro una et eadem causa. No one should be punished twice for the same cause. Instead, it's purely a coercive measure for the failure to pay the fine, carefully balancing the state's right to enforce its penalties with individual liberty and fairness.
Preventing excessive punishments and safeguarding fairness sections 9 and 10.
That deep dive into fines really shows the intricate balance the law tries to strike between punishment, enforcement, and fairness. Now, how does the BNS prevent a situation where an offender might be punished multiple times for essentially the same criminal act, perhaps because it fits under different legal definitions? Or what happens when there's genuine doubt about which specific offense was committed? Let's introduce sections 9 and 10, which seem to focus precisely on preventing excessive punishment and safeguarding fairness in these tricky situations.
Yes, these sections are critical safeguards. They embody important principles of criminal jurisprudence, particularly aimed against imposing disproportionate or potentially duplicative punishment for what might be considered a single criminal transaction or where ambiguity exists.
Okay, let's start with section 9. Limit of punishment of offense made up of several offenses. What's that about?
Its core concept is to prevent the duplication of punishment for what are essentially composite offenses, or situations where a single act or a series of acts forming one transaction happens to fall under multiple technical definitions of offenses within the BNS. The object is fundamentally about fairness in sentencing and upholding the spirit of the principle against double jeopardy, meaning you shouldn't be effectively punished twice for the same wrongful conduct, even if it technically fits several different labels in the Code.
How does it work in practice?
It covers a few scenarios. Subsection 1 says that if anything constitutes an offense, and that offense is made up of parts where each part is also technically an offense, the offender won't be punished for more than one of those constituent parts, unless it be so expressly provided by the law.
So you punish the whole, not each individual piece.
Generally, yes. The classic illustration helps. If A gives Z 50 strokes with a stick. Technically, each stroke might be considered an act causing hurt, but under this provision, A is liable only for one punishment for the whole beating, treated as one composite offense, not 50 separate punishments for each stroke.
That makes practical sense. What else does it cover?
Subsection 2 extends this principle. It covers two situations. First, if an act falls under the definition of two or more separate offenses. Second, if several acts, where one or more would individually constitute an offense, combine to form a different, distinct offense when taken together. In either of these cases, the rule is that the offender shall not be punished with a more severe punishment than the court could award for any one of such offenses.
So if my actions fit crime A max 3 years and crime B max 5 years, I can't get more than 5 years total for that single course of conduct.
That's the essence of it. It puts a ceiling on the overall severity of punishment stemming from a single criminal episode that might technically violate multiple sections. However, it's important to distinguish this from genuinely separate, distinct acts. The illustration clarifies. While A is beating Z, A then intentionally strikes a bystander Y. That blow to Y is a completely separate offense involving a different victim and potentially different intent, and it can be punished distinctly. It's not part of the act of causing hurt to Z.
So it depends if it's truly one transaction or separate ones.
Correct. Section 9 embodies a clear legislative intent to prevent an offender from being punished multiple times or excessively for what is essentially the same criminal conduct or transaction. It's closely connected to the principle against double jeopardy, not just in the procedural sense, can't be tried twice, but in preventing substantive overpunishment arising from how charges might be framed for a single incident. It's an aha moment for understanding the practical limits placed on prosecutors who might otherwise try to stack multiple charges for essentially one event to maximize potential punishment.
Okay, that protects against excessive punishment for one act. What about Section 10? Doubtful offenses.
Section 10 addresses a different kind of fairness issue. Punishment of person guilty of one of several offenses, judgment stating that it is doubtful of which. This codifies the principle of leniency or benefit of the doubt, specifically at the sentencing stage.
Benefit of the doubt in sentencing. How does that work?
The core concept is straightforward. If a court finds a person guilty, but the judgment explicitly states that it's doubtful which of several possible offenses specified in the charge or finding the proven facts actually constitute, and the punishments for those possible offenses are not all the same.
So the court knows they did something wrong, but isn't sure exactly which crime it fits.
Precisely. In that specific situation of declared judicial doubt between defined offenses, the rule under Section 10 is that the offender shall be punished for the offense for which the lowest punishment is provided.
Always the lowest punishment if there's doubt between options.
Yes, if the doubt is formally acknowledged in the judgment. The object here is fundamental fairness. It ensures an offender isn't subjected to a harsher punishment when genuine ambiguity exists regarding their precise legal culpability, even after conviction. It operationalizes the benefit of the doubt directly into the sentencing calculation. This is a direct application of the broader legal principle known as the rule of lenity, which generally states that ambiguous criminal statutes, especially concerning the severity of punishment, should be construed in favor of the accused. It's a testament to the idea that it's better to err on the side of caution when liberty is at stake and the law isn't perfectly clear on the classification of the proven conduct.
The strict regime of solitary confinement sections 11 and 12.
These sections really highlight the law's commitment to fairness and preventing overreach, both in multiple punishments and when there's doubt. Now let's turn to a particularly sensitive and often controversial form of punishment: solitary confinement. This has serious human rights implications globally, we know that. How does the BNS regulate its imposition and, importantly, its execution? Let's look at sections 11 and 12, which seem to establish a very strict regime around it.
Solitary confinement is indeed an exceptionally harsh form of punishment, and its regulation is absolutely critical due to significant human rights concerns recognized widely under international covenants and constitutional principles. Sections 11 and 12 of the BNS together establish a stringent, carefully circumscribed regime for it, reflecting, I think, a careful balancing act between the state's power to punish severely and the imperative to maintain humane conditions.
Okay, so section 11 first, the power to impose it. When can it be used?
Section 11 deals with the solitary confinement itself, the power of the court to impose it. Its core concept is the judicial imposition of this severe measure, clearly intended as an added deterrent or punitive element only for specific, serious crimes. It's not a general option.
What are the conditions?
Firstly, it can only be ordered for offenses where the sentence includes rigorous imprisonment. So it's automatically excluded for offenses punishable only with simple imprisonment or fine.
Only for rigorous imprisonment cases. Are there limits on duration?
Yes, very strict limits. The total period of solitary confinement awarded in any single sentence cannot exceed 3 months in total. And even within that 3-month maximum, the actual permissible duration is carefully scaled according to the length of the substantive rigorous imprisonment sentence.
Scaled?
Like this. If the total term of rigorous imprisonment is 6 months or less, the solitary confinement cannot exceed 1 month. If the rigorous imprisonment is more than 6 months, but not more than 1 year, solitary confinement cannot exceed 2 months. And only if the rigorous imprisonment is more than 1 year can the solitary confinement reach the absolute maximum of 3 months.
So it's capped and scaled. Why such strict limits?
This careful scaling reflects clear legislative caution. It acknowledges the inherent harshness and the potentially severe psychological toll of solitary confinement. Its relevancy connects directly to human rights jurisprudence. Landmark Supreme Court cases like Sunil Batra v. Delhi administration emphasize the need for strict adherence to legal safeguards for any form of solitary confinement, whether imposed by a court or by prison authorities, precisely because of the risk of arbitrary or inhumane application and the severe psychological effects of prolonged isolation. The aha moment here is seeing just how restrictive these provisions are. Solitary confinement is treated legislatively as an extreme measure, not a routine one.
Okay, so Section 11 limits if and for how long it can be imposed in total. What about Section 12?
Section 12 then provides the limit of solitary confinement, specifically during its execution, how it's actually carried out. Its core concept is the humane regulation of the punishment, ensuring that even when legally imposed, it's not carried out in a way that amounts to continuous, unrelenting isolation.
So rules for how the prison implements the sentence.
Exactly. It mandates that such confinement shall in no case exceed 14 days at a time.
Only 2 weeks maximum in one stretch.
Yes. And crucially, there must be intervals between these periods of solitary confinement, and these intervals must be not less than the duration of the confinement itself. So if someone serves 14 days in solitary, they must have at least 14 days out of solitary before the next period can begin.
Equal time out, as in?
At least equal time out. And there's a special, even stricter rule for longer overall sentences. If the total substantive imprisonment awarded exceeds 3 months, the solitary confinement imposed under the sentence shall not exceed 7 days in any 1 month of the whole imprisonment awarded. And again, the intervals between these 7-day periods must be at least as long as the periods of confinement.
Wow, only 7 days a month if the sentence is long. That's very specific.
It is. These rules are clearly designed to prevent continuous, prolonged isolation and to mitigate the risk of extreme psychological harm associated with it. Sections 11 or 12, read together, therefore, create a very strict two-layered framework. Section 11 limits the court's power to impose it in the first place, and Section 12 strictly regulates how prison authorities can carry it out. It's a balance between allowing a harsh punishment for serious crimes involving rigorous imprisonment while simultaneously upholding the constitutional imperative to prevent inhuman or degrading treatment, ensuring basic human dignity even for convicted prisoners. It's a stark reminder of the state's responsibility to regulate even its most severe punishments.
Recidivism and enhanced punishment, Section 13.
That's a very clear illustration of the legislative intent to tightly regulate even the harshest punishments, making sure they're not just imposed arbitrarily, but executed, hopefully humanely, and within very strict limits. Okay, finally, for this foundational block, what happens when an offender repeatedly commits certain types of crimes? How does the BNS address the issue of habitual offenders or recidivism? Let's look at Section 13, which deals specifically with enhanced punishment for previous convicts.
Section 13 codifies the principle of recidivism. This is the legal concept that dictates that repeat offenders, particularly those who repeatedly commit certain classes of serious crime, may warrant more severe punishment than first-time offenders for the same subsequent crime. Its core concept is to enhance the deterrent effect of the law specifically on habitual offenders, and arguably to better protect society from those who persistently engage in specified types of criminal activities. It's a legislative recognition that for some offenders, the standard punishment hasn't been a sufficient deterrent.
So harsher penalties for repeat offenders. How does it work? Does it apply to any repeat crime?
No, the conditions for applying this enhanced punishment under Section 13 are actually quite specific and targeted. It doesn't apply universally to all repeat offenses.
What are the conditions then?
First, there must be a previous conviction by a court in India for a specific type of offense.
Okay, a prior conviction. For what kind of offense?
Second, this previous offense must have been punishable under either Chapter X, which deals with offenses relating to coin, currency notes, banknotes, and government stamps, or Chapter 7, which covers offenses against property of the BNS. And, crucially, that prior offense must have been punishable with imprisonment of 3 years or upwards. This sets a clear threshold for the gravity and type of the prior crime. It focuses specifically on certain economic and property offenses.
So only prior convictions for serious property or current system-related crimes count?
Correct, for the purpose of triggering this specific enhancement section. Third, the offender must then be found guilty of a subsequent offense.
Okay, they commit another crime after the first conviction?
Fourth, this subsequent offense must also fall under either Chapter X or Chapter 7 and also be punishable with, like, imprisonment for the like term, which again implies imprisonment of 3 years or upwards.
So they have to repeat a similar type and severity of crime.
Exactly. It's about a pattern of serious offending within these specific categories of property and economic crime. If all these conditions, prior conviction for a specific type severity, subsequent conviction for a similar type severity are met, then the enhanced punishment for that subsequent offense becomes significantly harsher. Instead of the standard punishment for that subsequent offense, the offender becomes liable for either imprisonment for life or our imprisonment of either description for a term which may extend to 10 years.
Life or up to 10 years. That's a big jump from potentially just 3 years for the second offense on its own.
It's a very significant enhancement, yes.
So it's not just any repeat offense. It's very specific to crimes related to currency and property, and only if the previous conviction was already for a serious crime in those areas. That's a very targeted approach, isn't it? What's the sort of aha moment or the reasoning behind targeting these specific crimes for enhanced punishment?
Exactly. The targeting is the key insight here. The aha moment lies in recognizing what the law chooses to focus on for enhanced punishment of recidivists. This provision's relevancy is clearly in its aim to enhance both specific deterrence, discouraging this individual offender from doing it again, and general deterrence, sending a message to others, and also, frankly, incapacitation, keeping persistent offenders off the streets for longer.
Why these crimes, though? Property and currency.
It specifically targets these economic and property crimes, likely reflecting a legislative assessment of their significant impact on societal order, economic stability, and public trust. These are the kinds of crimes that can directly harm individuals' livelihoods, undermine financial systems, or erode faith in the security of property and commerce. It's a clear legislative statement that a persistent pattern of serious offending in these particular areas is viewed with extreme concern and will result in significantly harsher penalties. The theories underpinning this are clearly deterrence and incapacitation. It shows where the law perceives a particularly strong need for enhanced protection and deterrence against repeat habitual offenders. Outro. So looking back across these foundational sections, Preamble through Section 13, what's truly fascinating is how they collectively establish the very grammar and vocabulary of India's new criminal law landscape. We've seen, I think, a meticulous effort to balance long-standing traditional legal principles with the undeniable needs of modern society.
Yeah, like the cybercrime jurisdiction you mentioned.
Yeah, exactly. That robust approach to cybercrime jurisdiction, even with its enforcement challenges, the progressive introduction of community service as a sentencing option, and the very careful, humane considerations embedded in the regulation of something as harsh as solitary confinement, these all point to that balancing act.
It's not just a technical update, then.
I don't believe so. It seems to be a thoughtfully constructed framework aiming for clarity, consistency, and ultimately fairness in how criminal law operates. These initial sections are certainly more than just dry legal text. They represent, I feel, a profound statement about India's evolving approach to defining crime and administering justice in the 21st century.
So what does this all mean for you listening in? Whether you're a legal professional trying to navigate this new landscape, maybe a student eager to understand the evolving justice system, or perhaps just someone who is, as we like to say, insanely curious about how laws shape society. Understanding these foundational elements, the preamble's intent, Section 1's reach, Section 2's definitions, Section 3's rules of liability, and Sections 4 to 13 on punishment and sentencing principles is absolutely crucial. It's the bedrock for anyone interested in the future of justice in India.
Couldn't agree more.
The BNS 2023 clearly represents not just a change in law books, but a significant reimagining of how India defines crime and justice. And maybe here's a final provocative thought for you to mull over. As new challenges inevitably emerge in our society, things perhaps unforeseen even by today's lawmakers, what further evolutions might we see in these very definitions and principles as they are tested and interpreted in the courts and, well, on the streets in the years to come? How will this foundation hold up and adapt?
That's the ongoing question for any legal system.
Indeed. That's our deep dive for today into the foundations of the BNS. Until next time, keep digging.